Now let's talk about the Corporate Transparency Act. This was recently passed and it was hidden inside of the National Defense Authorization Act. I've not only read the entire act word for word, but I've studied it with a fine-tooth comb, studied what the authors say about it, and now this act requires one to file a report about the beneficial owners of every company in the United States to the Financial Crimes Enforcement Network, or FinCEN for short, a bureau of the U.S. Treasury. Now, I'm going to shine a bright light on it, expose it. I'm going to talk about the good things, the bad things, and what you need to do as a business owner and as a practitioner. Now, first of all, this is a big deal because every owner of a U.S. company needs to do it, as you will see. Everyone who sets up a U.S. company on behalf of others, including attorneys, needs to do it. And because the penalty is up to 3 years in prison and a $10,000 fine for not doing it. Plus, under Title 18, $250,000 to $500,000 for providing false information about it. So what I'm talking about here is a big deal, and my purpose as you watch this whole thing is to be the most complete video on the internet on the subject, telling you exactly what you need to do. So I highly suggest you watch this short video to the end. And at the very end, I'm going to tell you what I uncovered. The most shocking thing about this brand new law and how it massively increases the privacy of ownership of corporations and LLCs for law-abiding citizens. Hi, I'm the business guy, and today we're going to talk about the Corporate Transparency Act. And if you could do me a favor and please click the like button below, it would help me a lot for the YouTube algorithm. I sure appreciate it. And in the comment section, tell me what you think. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. Now, I've been the CEO of a legal document firm for 30 years. This is my perspective and that of our on-staff attorneys. But don't take this video as legal advice. You can call our offices and speak with one of our attorneys. We've filed literally millions of pages of documents, most of which are corporations and LLCs, both in the U.S. and internationally. So some would say that would qualify me to talk about the subject. Now, first of all, my opinion. There are incredible tax and lawsuit protection benefits for operating your business in corporations and LLCs. So in spite of this law, operating without a company is not a good option. And frankly, as the CEO of one of the leading firms that forms companies in the U.S., I'm not happy about this law. I think it is well-meaning, but places an additional, unnecessary, ongoing layer of paperwork on the owners of every company in America. Plus, when filing taxes, the tax filings already report the ownership of the company anyway. So there's no need for an additional reporting requirement simply because of government database inefficiencies. Moreover, there are easy and obvious ways around it. First of all, this only applies to U.S. companies, not offshore ones. So one can simply operate using an offshore company. Plus, there is a certain kind of trust that our on-staff attorneys set up to own real estate and other assets where one can maintain privacy of ownership. So if you are a good, honest business person who simply wants extra privacy, give us a call for more information and we can help you do that legally. But be that as it may, it is the law and we are all subject to it. And we have no legal choice but to comply. I don't like going through security at the airport either. I'm a good guy. I'm not going to hijack any airplanes. But I can lay on the ground and kick and scream and cry, or I can lay my bags on the conveyor belt and walk through the body scanner. Only one way will get me to the plane so I can see my family on the other side of the country. Okay, now for a little background. The justification for Democrat Congresswoman Carolyn B. Maloney's sponsorship of this bill is that she says nearly 2 million corporations and LLCs are formed in the U.S. every year. Very few states require information about who owns them, and I admit I must agree. We are by far the largest offshore company firm in the nation, see offshorecompany.com, and in order to set them up, we need a reference letter from the person's banker, a reference letter from a CPA or attorney, the company purpose, the source of funds, a notarized copy of a utility bill or other residential address verification, and a notarized copy of a passport. So 6 things. To set up a U.S. company, we just needed the name of the first director, and for an LLC, this can be another company as its manager. That's it. No proof of anything. They say that criminals launder money through these companies to buy buildings and other assets, and law enforcement cannot find who owns them. And as someone who sets up thousands of companies, I don't want the bad guys contacting us to set up their companies. I pound this into our staff on a regular basis that we only want good, clean, honest business, and all others we just turn away. Okay, now, with that backdrop, let's get down to the bottom line. As a business owner or practitioner, what do you have to do? When setting up a company, you must report the beneficial owners to FinCEN. Now, so I don't keep repeating myself, here's how the Act defines beneficial owner. A beneficial owner is someone who exercises substantial control over a corporation or LLC formed in a U.S. state or Indian territory, like through a contract. Number two, someone who owns 25% or more of the company. Or number three, someone who receives substantial economic benefits from its assets. So one or more of these things, control, ownership, benefits, as stated above, are what the Corporation Transparency Act calls a beneficial owner. Now, when you form a company or are a beneficial owner, you must provide FinCEN these four things. For U.S. people, you must report their full legal name, their date of birth, a current residential or business street address, a passport, driver's license, or other government-issued ID card number. Now, it doesn't say you need a copy of that document. It just says that you need to report a number from that document. No financial information or details about the business purpose or its operation is required. Just those four things: name, birth date, address, and ID number. Now, if you are an applicant, such as an attorney, setting up a company and are not a beneficial owner of the entity, you not only need to report all beneficial owners, you also need to provide that same information on yourself, the applicant. You can also ask for a FinCEN number. Anybody who asks for it can get one to shortcut the process. Now, for foreign people, it's different. For foreign beneficial owners who don't have U.S. driver's licenses or passports, the applicant must provide FinCEN these five things: the full legal name, their current residential or business street address, a unique identifying number from a non-expired passport issued by a foreign government, and number four, a legible and credible copy of the pages of a non-expired passport issued by the government of a foreign country bearing a photograph, date of birth, and unique identification number for each beneficial owner. And number five, written certification that the applicant has obtained the following for each beneficial owner: a current address, a legible, credible copy of the proper pages of the passport, verify the legal name and address and identity of each person, and that they will provide that information to FinCEN upon request, and the proof that they verified it. And that they will keep a copy of the ID and proof that they verified the information, and keep all of that for 5 years after the corporation or LLC terminates. So not just 5 years after you file it, 5 years after the company is defunct, which may be 10, 20, 50, 100 years or more, and 5 years after that. So apparently, you need to put those papers in your coffin so they can dig you up and find out who owned it. So there you go. But don't worry, call us, and we have attorneys on staff, and we have a service where we can help you comply with this law. And we also sell extra large coffins for those who file lots of companies. Now, what about existing companies? You have to report this within 2 years of the enactment of this law, which appears to be October the 23rd, 2019. So according to this, you have until October 22nd, 2022 to provide FinCEN with the above documents. Okay, now let's talk privacy. Someone can only get your beneficial ownership information that's been reported to FinCEN in 3 ways. 1, a request by a local, tribal, state, or federal law enforcement agency. Number 2, a request made by a federal agency on behalf of a law enforcement agency of another country, and each must prove to FinCEN they really have the right to it. Or number 3, a request made by a financial institution with consumer consent. So unless you're a bad guy, you really have nothing to worry about. Not even a bank can get the information without your consent. Okay, now, you need to file this information every year, just like you file taxes every year. And this is an annual filing, and more about privacy later. Penalties. Now, bad things can happen if you, 1, provide false ownership information or fake ID documents to FinCEN. Number 2, and this is a big one, you willfully fail to provide complete or updated beneficial ownership information. Or number 3, you receive a subpoena and you knowingly disclose its existence or other requests for beneficial ownership information, unless doing so is needed to fulfill the request or the enforcement agency authorizes it. So if you do any of those things, provide fake info, willfully fail to provide the info, or blabber about a subpoena for the info, you can be subject to a civil penalty for $10,000 and under Title 18, which is up to $250,000 for individuals and $500,000 for organizations, plus up to 3 years in prison. It also adds that if you're just negligent, say you didn't know you had to do these things, you're not going to get into trouble. And the Secretary of the Treasury can waive the penalty if it was due to reasonable cause and not willful neglect. Now let's talk more about privacy. Here's one of the amazingly good things. Now, when I read this provision, I almost hit the floor. This, I think, is a good thing for privacy advocates. Part 5 of this subsection says criminal penalty for misuse or unauthorized disclosure of beneficial ownership information. It says the criminal penalties provided under 5322 shall apply. So Title 31 of U.S. Code Section 5322 says you can be fined for not more than $250,000 or imprisoned for not more than 5 years or both. So if I read that right, which I think I did, disclosing the owner of a U.S. corporation or LLC, and you may have to shell out over $250,000 and sit in the clink for 5 years. So they gather this information from the owners, but only agencies such as law enforcement doing investigations can access it. This means that even someone sniffing around who's trying to sue you or actually does sue you in civil court cannot access it. Better yet for privacy, it clearly states that you can have a nominee such as a nominee officer or director in the public records so that your name doesn't show up for someone who might be sniffing around for assets. This is a service we provide for law-abiding clients who just want to protect their assets from prying eyes. So FinCEN will know who the owners are, but that big ugly guy who wants to sue you may not. Now, beneficial owners don't include minor children, nominees and the like, a mere employee, one who inherited the company, or a creditor of a company unless that creditor is also a beneficial owner. Offshore companies. Again, this law does not apply to offshore corporations or LLCs. We set up tens of thousands of offshore companies for law-abiding citizens. You can visit us at offshorecompany.com. So you can have an offshore company and this law does not apply. Exempt companies. The full reporting requirement also does not apply to publicly traded companies, financial institutions such as banks, or exempt nonprofits such as churches. Now here's a big one. If you have more than 20 full-time employees in the United States, your income taxes show more than $5 million in gross receipts, and you have an operating presence at an office in the U.S., you're exempt. Or if the Secretary of the Treasury and the U.S. Attorney both agree that you should be exempt. But, as we said, even if you are exempt from reporting, you still have to file a report as to which particular provision in the code makes you exempt. And the person making this filing must report and provide the same information that a beneficial owner would have to provide, such as name, address, birth date, and ID numbers. So all companies in the U.S., even those who are exempt for reporting, still has to file a report. Okay, so what are the takeaways from all this? First, every company needs to file a report to FinCEN, even exempt companies. If you set up a company for others, such as an attorney, you need to report the beneficial owners as well as yourself. This law applies to U.S. companies only, not to offshore ones and not to trusts like the ones we set up. So if you need help fulfilling this legal requirement, don't sweat it. We have a service where you can hire us to do this for you. Our number is 1-661-310-2931, or you can visit us at assetprotectionplanners.com and fill out a free consultation form. And please be sure to click the like button below and subscribe to this channel. This is The Business Guy.